India Legal presents Courts Roundup.
Hello, I am Tanya Chugh and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court says order extending limitation due to COVID-19 still operative. Direct NCDRC to take on record a written statement filed belatedly. In a setback to future retail, the Delhi High Court has refused to restrain Amazon from interfering in the Kishore Biani-owned company's deal with Reliance Retail. Gujarat High Court takes Suo Motu cognizance of children not getting midday meal, issues notice to government. After taking Suo Motu cognizance, Karnataka High Court stays state government notification to drop 61 criminal cases against ministers, elected representatives.
India Legal presents Courts Roundup.
The Supreme Court observed that its order of 23rd March 2020 extending limitation for filing in courts and tribunals is still operative. The bench comprising Justices Vineet Saran and S. Ravindra Bhatt observed thus while setting aside an order passed by National Consumer Disputes Redressal Commission, which declined to take a written statement on the ground that it has no power to extend the time for filing the response to the complaint beyond 45 days.
The court noted that in this case the period of 30 days to file written had statement expired and the same was filed only thereafter. It is true that the decision of the Constitution Bench of this court in New India Assurance Corporation Limited, Hilly Multipurpose Cold Storage Private Limited clearly provides that no written statement is to be allowed to be filed beyond the period of 45 days as per Section 38 of the Consumer Protection Act 2019. The bench noted. The bench observed that the limitation for filling the written statement in the present proceedings before the National Commission would be deemed to have been extended, as it is clear from the earlier order that the extended period of limitation was applicable to all petitions, applications, suits, appeals and all other proceedings. The bench observed the above order is still operative and by subsequent orders the scope has been enlarged so that the said order applies in other proceedings also. In the present matter, it is an admitted fact that the period of limitation of 30 days to file the written statement had this period expired when the order passed by this was continuing. As such, the delay of 4 days in filing the written statements in the pending proceedings before the National Commission deserves to be allowed and is accordingly allowed. Allowing the appeal, the bench directed the Commission to take on record the written statement filed by the appellant shall be taken on record. On April 6, the court extended the application of the order to proceedings under Arbitration Act and Section 138 of the Negotiable Instruments Act. On July 10, the court applied this Suo Motu order extending limitation for filing of cases to Section 29A and 23A of the Arbitration and Conciliation Act 1996 and Section 12A of the Commercial Codes Act 2015. On 18 September, the CJI-led bench clarified that the said order extended only the period of limitation and not the period up to which delay can be condoned in exercise of discretion confirmed by the statute. The court held that the expression prescribed period appearing in Section 4 of the Limitation Act cannot be construed to mean anything other than the period of limitation. Bureau Report.
In a setback to future retail, the Delhi High Court has refused to restrain Amazon from interfering in the Kishore Biani-owned company's deal with Reliance Retail by writing to statutory authorities.
Delhi High Court has dismissed a plea from Future Group that sought to restrain US partner Amazon.com Inc. from interfering in its $3.4 billion asset sale to Reliance Industries. The order was pronounced by a single judge bench of Justice Mukta Gupta in the suit by Future Retail Limited after an emergency arbitrator of the Singapore International Arbitration Centre restrained Future Group from taking any steps in furtherance of the transaction with Reliance Retail. The court held that the statutory authorities were free to form their own opinion as per law. Future sold its retail assets in August to Reliance Industries in a deal Amazon said breached arguments Future made with the US e-commerce leader in 2019. In findings for Future Retail and Amazon, the court prima facie found that the suit filed by Future Retail was maintainable. The emergency award was valid and that Future Retail's resolution approving the transaction with Reliance was also valid. The court also stated that the prima facie, the conflation of the three agreements, that is, Future Retail Shareholding Agreement, Future Coupons Private Limited (SHA) and FCPL Share Subscription Agreement, granted disappropriationate rights to Amazon, which required government approvals under FEMA FDI rules. In October, Amazon had won an injunction to halt the sale from a Singapore arbitrator that the sites had agreed to use in case of dispute. Future later said the order was not binding, prompting Amazon to lodge a complaint with market regulator Securities and Exchange Board of India. The Competition Commission of India last month approved Future's sales of its retail, wholesale, logistics and warehousing businesses to billionaire Mukesh Ambani's Reliance. Future Retail Limited had announced its deal with Mukesh Ambani-owned Reliance Retail Ventures Limited earlier this year. Bureau Report.
In a setback to the B.S. Yediyurappa-led government, the Karnataka High Court has stayed the government order dated August 31st, by which it had decided to drop the criminal prosecution in 61 cases against elected representatives and ministers.
In a significant order, the Karnataka High Court has stayed a state government decision by which it had decided to drop criminal prosecution in 61 cases against elected representatives and ministers. The High Court order sending strong signals against political interference in prosecution of MLAs, MPs was passed by a division bench comprising Chief Justice Abhay Srinivas Oka and Justice Vishwajit Shetty. The court also directed the state government file its statement of objections to the petition by January 22, 2021. It was hearing a plea by NGO, People Union of Civil Liberties Karnataka, challenging the August 31 order wherein the government had granted permission for the withdrawal of prosecution of the 61 cases under the Section 321 of Code of Criminal Procedure. During the previous hearing, the court had observed that the trial courts are not bound by such decisions by the government and it can apply its own mind and reject prayers for withdrawal of prosecution. No court is bound by such a decision taken to withdraw from the prosecution. Even if an application is made under Section 321 of CRPC, the courts are duty bound to assess whether prima facie case is made out or not and that the court has power to reject the prayer, the order had said. It had also opined during the previous hearing that a public prosecutor cannot act like a post box or submit to the diktats of the government when the executive directs withdrawal of criminal cases against legislators. The prosecutor should act objectively as he or she is an officer of the court, the High Court had added. As per the plea, the case being withdrawn include against the state's Law Minister J.C. Madhuswamy, Tourism Minister C.T. Ravi and Agriculture Minister B.C. Patil. A case from 2017 against Hospit MLA Anand Singh is also sought to be withdrawn. Advocate Clifton D. Rosario, appearing for the petitioners, had argued that the decision was against the rule of law. The cabinet decision to withdraw prosecution in 61 cases was taken on August 31, 2020 under Section 321 of Code of Criminal Procedure. Bureau Report.
Welcome back. You are watching Courts Roundup. The Allahabad High Court has taken to task jail authorities who refused to release an accused despite court orders. This was apparently because the name of the applicant was spelled wrongly in the bail order.
Jail authorities of district jail at Siddharth Nagar in Uttar Pradesh, who refused to release a man for 8 months because of missing middle name Kumar in the bail order, attracted the reprimand of Allahabad High Court, which berated the reprehensible conduct of the jail superintendent. In an order passed on December 7, the court noted that the jail superintendent refused to comply with the release order passed in April this year, only because the name of the applicant mentioned in the release order was Vinod Baruar, whereas in the remand sheet it was Vinod Kumar Baruar. A single judge bench of Justice J.J. Munir said that it did not appreciate the fact that his order was flouted with such impunity in the guise of a small technicality. It is on that small technicality that the jail superintendent or jailer has flouted the bail order of this court by refusing to release the applicant. This court does not appreciate our orders being flouted with impunity. This court fails to understand that when the applicant's name mentioned in the bail rejection order is Vinod Baruar, then why Kumar must be added to the name mentioned in the bail order. In order to make it effectual, the High Court noted, although the applicant had made an application for correction of his name to the trial judge, his plea was logically refused. The High Court opened that the conduct of the jail superintendent who had refused to release the applicant was not only reprehensible but also contumacious. The sole purpose of not complying with the bail orders for all these 8 months appears to be prima facie an obstinate attitude of the jail administration in carrying out the orders of this court. In the process, they have deprived a citizen of his liberty without any just or reasonable cause since April 2020 till date, the bench added. The court therefore ordered that the applicant Vinod Baruar be forthwith released within 24 hours in terms of the bail order dated April 9, 2020 passed by this court. The concerned jail superintendent Rakesh Singh was also directed to appear before this court and explain why appropriate departmental inquiry may not be recommended against him. Baruar was later released by an affidavit filed in this regard by the jail superintendent was taken on record. In an order passed on the very next day, the court said that it was reluctantly accepting the explanation offered by the jail superintendent. The court then proceeded to close the case after warning the jail superintendent to be careful in future. Bureau Report.
The Gujarat High Court issued notice to the Principal Secretary, Education Department, Government of Gujarat and Commissioner regarding the midday meal schemes of State of Gujarat. The division bench of Justice J.B. Pardiwala and Justice Ilesh J. Vora took Suo Motu cognizance after taking into account a news report that midday meals are not being made available to 52 lakh children since March 2020. The state government is not providing midday meals to the children and neither ration or food coupons were issued to them. In a survey conducted by the Indian Institute of Management, Ahmedabad, and the UNICEF Gujarat, 85% of the parents said that since March, children are not getting any benefit of the midday meal scheme. Even in the month of March, only 30% of the children took advantage of it. Gujarat Congress Chief Spokesperson Manish Doshi had recently raised the issue that 52 lakh children of poor and general category who were getting benefits under the midday meal scheme are not getting it since March. The government also did not provide ration or food coupons to these children. Doshi said the government used to distribute milk to the children in tribal areas, which is completely closed during the coronavirus epidemic. The Madras High Court declined to grant an interim stay on the Tamil Nadu ordinance banning online gambling and online games, including online rummy games. The second such instance when the court has refused to stay the ordinance. A bench of Justices R. Subbiya and C. Saravanan, however, posted the matter for final hearing on January 18, after the state sought more time to file its counter affidavit. The court had earlier refused to stay the ordinance on a petition moved by online gaming platform Jungli. In that case, the state had undertaken to file its counter in the matter. Appearing for the state, Advocate General Vijay Narayan today sought more time and urged the court to adjourn the matter till the after Pongal. Opposing prayers for an interim stay, the Advocate General argued that the ordinance would have minuscule effect on the operations of the petitioners given that only two states, Tamil Nadu and Andhra Pradesh, have banned online rummy. He argued further that there is evidence to show that children are playing online rummy using their parents' credit card. Notably, he added that there is possibility for the government to table an act against online games in the forthcoming Legislative Assembly session, which may not necessarily be in the same form as the ordinance under challenge. Therefore, he urged that matter be taken up after Pongal, prompting the court to post matter for hearing on January 18. The court cautioned that no further extension of time will be given to file the counter. Justice G.S. Patel of the Bombay High Court has passed an interim order of injunction against Aristo Apparels, restraining them from using the Savla Corporation's trademark Cero or any derivatives containing the Cero mark on men's apparel. Savla approached the High Court after they discovered that Aristo was selling products under the mark Ceron and had also applied for registration of the Ceron label mark in the same class as Cero. Upon examining the two rival marks, the court found similarities between the two and noted that both marks were used in respect of the same class and types of goods, ready-made garments and menswear. He observed that there is no manner of doubt in my mind that plaintiff has made out a sufficient prima facie case. The defendant's mark is confusingly and deceptively similar to that of plaintiff's prima facie. It would appear that defendant is trading on plaintiff's goodwill and reputation. Justice Patel observed that Savla had invented and registered the Cero mark before Aristo did, and that Aristo was aware of the same. From social media pages, promotional materials and sales figures, the court opined that there was sufficient material to show the distinctiveness of Savla's marks and that these marks uniquely identified as Savla's mark. As such, Savla was granted an interim relief, with the High Court restraining Aristo using the Cero or any other mark containing the word Cero together or by itself or with any other word. The division bench, headed by Chief Justice Sanjay Karol of the Patna High Court, has created a record of sorts in video conference hearings. The bench has disposed of about 4,000 cases of the Excise Act. In the virtual hearing too, the bench of Chief Justice has stopped. Through the bench, more than 100 cases are heard or finalized each judicial day. At present, of all the benches of the High Court, the bench of Chief Justice has given the maximum time for the hearing and also made record for setting cases. According to the High Court Registry Office, the pending cases related to tax has also been updated. Similarly, the Chief Justice has executed most of the public hearing matters. Only 93 litigations of the 2018-19 remain pending. Many judges of the Patna High Court have set a figure maximum number of cases to be heard every day. Some judges have also written in the daily list that they will hear as many as 50 cases, while some have 30 and some have fixed 20 cases. The judges have decided how long they will hear the case. The execution of case has slowed down since the High Court heard the virtual case. This is the reason that hearing on the bail filed in August-September is going on. It is to be seen how the trial will be settled at fast pace in the virtual hearing, while the number of judges has come down to 22 and the trial period by the judge is getting shorter. That's all for Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.